Good afternoon, everyone. My name is Sarah Walburn. I'm a partner here at Secrest Wardle, and my topic for today is third-party contractors. So we'll start off with what a third-party contractor exactly is. And as you can see from the slide, a third-party contractor is an entity that has entered into a verbal or written contract with a premises owner to perform particular services. Some common third-party contractors in the premises liability context include some of the contractors that I have listed for you: landscapers, snow removal companies, irrigation companies, and roofing contractors. But they also include other entities like gutter installers or awning companies, cleaning crews, or parking lot resurface companies. The common contractor that you're going to see in these type of cases are generally going to be snow removal companies. We have a lot of cases out of the Court of Appeals and the Supreme Court involving a third-party contractor snow removal company's duty to perform its obligations under the contract, removing snow, laying down salt for the ice, and things of that nature. So, as I'm sure you know, in a negligence case, we generally have four elements that have to be proven by the plaintiff: duty, breach, causation, and damages. A threshold question in a negligence action, therefore, is whether the defendant owed a duty to the plaintiff. And that's kind of where we go with the third-party contractor situation. The duty in a premises liability case arises out of either a statutory duty, a contractual duty, or a common law duty. In the third-party contractor case, it's usually going to be a contractual duty. There's going to be a contract between the snow removal company and the premises owner to remove the snow, to lay down the salt, whatever the case may be. So what is the duty of a third-party contractor? Well, we have some case law that helps us out in this regard, but historically, with every contract, there was a common law duty to perform with ordinary care the thing agreed to be done. And a negligent performance constituted a tort as well as a breach of contract. So we have some significant developments in the case law. Now, in this first case, which I have listed on the slide here for you, Durbabian versus Mariners Point Associates, the defendant was a snow removal contractor, and he had the court held that he had no common law duty to plow, inspect, or salt the parking lot where the plaintiff was injured. The Court of Appeals held that the defendant did not breach a duty of care when it failed to inspect the parking lot on the day in question. The plaintiff did not have an independent tort action against the third-party contractor. So there was a distinguishing element between nonfeasance and misfeasance by the Court of Appeals. Now, nonfeasance is kind of the failure to perform the contractual duties, whereas misfeasance is more of the performance of the contractual duty in an actively negligent fashion, or actively causing a hazard or a danger. So based upon Durbabian, no tort claim arises solely from the defendant's failure to perform its contractual obligations. Next, we have the Fultz decision, which is a notable case. It's an important case. Again, the defendant was a snow removal contractor. The plaintiff had slipped and fallen on an icy parking lot, which the defendant allegedly failed to plow or salt. The Michigan Supreme Court rejected the misfeasance and nonfeasance analysis as too slippery. So the court looked at misfeasance as a separate and distinct element from the contractual obligation. So the court said that in Fultz, there was nonfeasance as opposed to misfeasance. So the court did not provide a detailed analysis of its separate and distinct approach. As the plaintiff's claim against the defendant was for the failure to perform its contractual duty of plowing or salting the parking lot, the claim failed under the separate and distinct analysis. The plaintiff's cause of action against the third-party contractor was therefore dismissed. And as you can see on the slide here, misfeasance may be a separate cause of action, separate and distinct from the contractual obligation. The Supreme Court reiterated that no tort claim arises solely from the failure to perform the contractual duty. Now, the Fultz progeny indicates that there is some conflict with Fultz. Now, I mentioned in the slide Banaszak and Mrzewiecki. Both of these were rejected in a later case called Loki, which we'll get to in a moment. But this case, the Banaszak case, further interpreted a third-party contractor's duty. It was later rejected by the court, but in Banaszak, the Otis Elevator Company was contracted to construct the elevators, escalators, and moving walkways throughout the Detroit airport terminal. They were required to cover a wellway or an opening at the end of the moving walkway that has the mechanical elements within it. The purpose of the cover, obviously, was to protect people using that area. Plaintiff was injured when she stepped on an inadequate piece of plywood covering the wellway. So according to the Michigan Supreme Court, the hazard was the subject of the Otis contract, so Otis owed no duty to the plaintiff that was separate and distinct from its duties under the contract. So even though the defendant clearly increased the danger to the plaintiff or otherwise committed a misfeasance, the court held that there was no distinction between the misfeasance and the nonfeasance. So there was no breach of a duty separate and distinct from its contract. This is in sharp contrast to the Fultz progeny. Similarly, the Mrzewiecki case, which I also cited on the slide that you can see, was also later rejected by the Supreme Court in Loki. Here, the defendant committed a misfeasance by piling the plowed snow onto a landscaped curbed island in the parking lot. The argument went that this created a new and unreasonably dangerous hazard because of the melting and the refreezing that occurred in and around those areas. So there was some concern about some ice in the area. Again, the Supreme Court rejected the plaintiff's argument that the defendant owed the plaintiff a duty separate and distinct from the contract, even though, similar to the Banaszak case, there was a misfeasance, the act of creating a more hazardous situation as opposed to a nonfeasance. So we come next to the Loki decision, which is the current state of the law. So in Loki, as mentioned above, Loki rejected the Banaszak case, the Mrzewiecki case, and other post-Fultz decisions that kind of curtailed or tried to do away with almost the separate and distinct duty regarding misfeasance. Loki arose out of an accident which occurred at a construction site where the plaintiff was working for an electrical subcontractor. The defendant's employee left a bunch of cement boards stacked against a hallway wall, which then fell on the plaintiff and injured his leg. The Supreme Court rejected the Court of Appeals holdings and indicated that Fultz did not distinguish the simple idea that is embedded deep within the American common law of torts. If one having assumed to act does so negligently, then liability exists as to that third party for failure of the defendant to exercise care and skill in the performance itself. So Fultz didn't extinguish that common law duty like the duty to use ordinary care to prevent physical harm to foreseeable persons or property. Rather, in looking to the contract first in the cases, the court in Loki clarified that under Fultz, the proper initial inquiry is, aside from the contract, whether the defendant owed an independent legal duty to the plaintiff. Therefore, a contracting party's assumption of contractual obligations does not extinguish or limit separately existing common law or statutory tort duties owed to a non-contracting third party in the performance of its contract. So essentially, the Supreme Court brought Fultz back to its primary holding of the difference between a nonfeasance and a misfeasance, and when a person who is not a party to the contract can then sue for a breach of a duty for misfeasance. So then that takes us to the Hill versus Sears case in 2012. Again, a Michigan Supreme Court case. This one addressed the issue of whether an appliance installer from Sears had a duty separate from their contract to install appliances. So the washer and dryer are getting installed in this person's house by the Sears appliance people. Apparently, there was an exposed uncapped gas line within the appliance area right there. So the Supreme Court took a look at this and said, due to their limited relationship, the installers did not have a duty to take any action with respect to that exposed uncapped gas line. They also did not have a duty to warn the homeowners about that uncapped gas line. The installers did not create a new hazard by placing the dryer in front of the uncapped gas line. So again, kind of going back to the non-feasance versus misfeasance analysis from Fultz. Bailey is kind of an odd case. This is the last case in determining whether a duty exists for a third-party contractor. This is a 2013 case, and I included it because the court remanded this case back to the Court of Appeals to determine the security company's duties pursuant to Loki's clarification of Fultz with the non-feasance versus misfeasance in a separate and distinct duty. The Michigan Supreme Court examined the issue of whether the third-party contractor called High Tech, which was the security personnel hired to patrol the premises, was under a duty to the plaintiff based upon the contract to provide security services for the premises owner. Apparently, the plaintiff was shot and paralyzed during an outdoor event at the premises common area. Now, the Supreme Court focused its attention more on the landlord management company's duties to the plaintiff to notify the police if given notice of a criminal situation on the premises. The Court of Appeals had stated that the facts alleged involving the contract between High Tech and the landlord would impute to the landlord the notice of the criminal situation. So the landlord had the duty to inform the police. That's kind of a side issue with respect to the contract between the landlord and High Tech. Again, as stated earlier, that the Supreme Court remanded this case back to the Court of Appeals to have a consideration of the non-feasance versus misfeasance analysis under the original interpretation of Fultz and Loki to decide whether there is a duty on the part of High Tech here. We'll be watching this case closely, and we'll give an update when we have one. So the moral of the story here, well, according to Loki, courts presented with a Fultz defense should begin their inquiry with an analysis of whether the defendant owed the plaintiff any legal duty that would support a cause of action in tort, and whether that be a common law duty or any sort of contractual duty. I know there's some issues with a third-party beneficiary of a contract, which Loki doesn't really speak to that. Neither does Fultz really a lot speak to that as well. But we'll be watching that closely as that case law develops. By referring to the broad common law duty to use ordinary care to prevent physical harm to foreseeable persons, Loki kind of opens that door for virtually any injured party to argue that they were owed an independent common law duty of ordinary care. So as I stated here in my slide, essentially if a third-party contractor performs an act, it must do so reasonably. So this is in large part returning to the former standard governing the misfeasance versus the nonfeasance. So a third-party contractor's failure to act, despite the contractual duty to do so, will not establish liability. However, unreasonable actions, regardless of the contractual language, may impose liability on a third-party contractor. So increasing the danger due to its negligence or creating a new hazard due to its negligence may impose the liability on the third-party contractor. Now, lastly, I had a quick little discussion here, and you can see it in my seminar materials and on the slide here as to the open and obvious defense with respect to third-party contractors. Those of you who practice or who work in the premises liability area know this open and obvious defense from Lugo. in order to, usually it's used in the slip and fall, trip and fall type situations. Now, can the open and obvious defense apply to a third-party contractor? And the short answer is probably not. I listed the case here, Ghaffari versus Turner Construction Company. The Supreme Court held that the open and obvious doctrine did not apply as it is specifically applicable to a premises possessor. In Ghaffari, the plaintiff was a subcontractor working at a construction site. So this wasn't a normal situation where we have a slip and fall and on ice or on a unlevel sidewalk, which those two are usually the most common situations, or in a grocery store slipping on something, a wet floor or some food that had fallen. Those are usually the times that you're going to see the open and obvious defense. This involved a subcontractor working at a construction site, and he tripped on some pipes on the ground and sued the construction manager as well as two subcontractors. The Michigan Court of Appeals applied the open and obvious defense, dismissing all the plaintiff's claims. Great for us. We were super excited about it. The Michigan Court of Appeals held there is nothing in the history of the open and obvious danger doctrine to suggest the doctrine should not apply in other contexts. So in context outside of the premises liability, slip and fall, trip and fall type situations. So the defense bar was pretty excited about this. We can go ahead and use the open and obvious defense in more construction type situations, which we were starting to see some more cases involving those. Then the Michigan Supreme Court granted leave to appeal and reversed the Court of Appeals and held that the open and obvious doctrine did not apply. According to the Supreme Court, the open and obvious doctrine is specifically applicable to a premises possessor. So the open and obvious defense probably is not going to apply in construction cases unless we get a change of the law by the Supreme Court here, which is likely not to happen. So in closing here, the open and obvious defense will probably not apply to most third-party contractors, but there's always a chance. So this concludes my presentation on third-party contractors. I appreciate everybody's attention, and if you have any questions, I'm in the Grand Rapids office. My telephone number is 616-285-0143. My direct is 616-272-7973. And you also see my email address there as well, swalburn@secrestwardle.com. Thank you very much. If you have any questions, please feel free to give me a call or email me at any time. Thanks.